Mr. Manenche, just one short question. It seems to me that looking at the cases that you've referred to that have been debated in court, this court's answer to the question whether the Parliament still retains control in matters such as this is that there can't be the control of Parliament that's required under the section 42, 43, 77 and 43, that intersection, is not absolute control. Would you say in this case then that Parliament still retains effective control? And how?
Yes, Justice Dambuza, there is limited control by Parliament in that it controls whether the increase by the minister will stay permanent. And that control happens ex post facto in relation to the increase. The initial increase takes effect immediately and applies for 12 months, irrespective of what Parliament does. So, and the VAT that's collected is not reversible. It's not refundable to the consumers. To that extent, the ex post facto control and the deliberation that takes place after the minister's implementation, we would submit, is not effective. Is not what is required in relation to the exercise of a taxing power. It must follow upon due deliberation by Parliament.
So there's no, the required oversight function is not there.
We identify only one oversight, which is that the increase or reduction, the alteration of the rate, applies for 12 months. The only intervention by Parliament affects whether it continues to apply beyond the 12 months. That's the first thing. It sets no limits as to by how much the minister may decrease or increase the VAT. That's entirely left to the minister. There are no trigger indications in the legislation itself to regulate the minister. There is no insistence of Parliament's disapproval or approval before the VAT takes effect, the increase or reduction. All of that happens on the day the minister indicates.
I guess what I'm trying to find out is whether it's real control or it's not real control, or the question cannot be answered in that manner.
We would submit that it is not effective control. Effective control should affect whether the increase would take effect for the full 12 months and the extent of the increase. That would be effective control, constraining the minister's exercise of that power that is given to the minister. At present, it simply depends on the minister entirely. And the only controls one, other than whether the rate remains permanent, that's the control Parliament has. The other control is whether that the minister must act rationally, but that also just means you can challenge it later, but it will not affect. The tax will have been levied and collected. They suggest that there is political control, if I can put it like that, or the accountability measures in the Constitution, that a minister, in this case, for instance, who proposed a VAT increase and was going to go ahead if there was no court order, irrespective of the fact that there was a sizable number of political parties opposed to the VAT increase in Parliament, maybe even a majority opposing the VAT increase. They say a minister who goes ahead, given a majority opposing the VAT increase, would risk their own continuation as a minister, and that it is a check on its own because of the accountability checks in the Constitution. But to that we say it's a political risk. It's not a legal risk. Nobody can come to court to compel the minister to withdraw the announcement merely because it is not supported by the majority. If it was done following the proper procedures, and one can't say it was irrational, the mere fact that it's opposed by the majority is neither here nor there. When Parliament passes legislation subsequently withdrawing the increase, it would have taken effect. And politicians take political risks all the time. There are many votes of no confidence, matters of public record, which have failed, not because the complaint has no substance, but because it's a power play. It depends on how the power dynamics are in Parliament, whether those accountability mechanisms function or not. So those are not, our learned friends, well, let me say their clients have listed a whole host of measures which they say the court must take into account. Most of them are not legally effective. They're simply, the High Court said, you're asking us to rely on the benevolence of the minister. I would say the political consciousness of the minister. But that is not something we as citizens can take our hopes on.
Thanks. I guess you're not going to make it easy for me, eh?
Thanks, Justice Dambuza.
Thank you, CJ.
As the court pleases, we've asked for our relief.
You have.
Thank you, Chief Justice. We intend to address the following issues in the following sequence. First, we address the broader context of the VAT Act, and in particular, the interrelationship between Section 7.1 and Section 7.4 of the Act. Second, we deal with the defining features of Section 7.4 that we say render it constitutional on any of the routes relied upon by the DA. Third, we address the role of Parliament in the process, and responding to the issues raised by Justice Dambuza, address the question of parliamentary oversight in the process. Fourth, we deal with the three challenges described by my learned friend as three routes in the DA's heads. We deal firstly with the pleaded challenges, which is the imposition challenge, and secondly, the plenary powers challenge. Lastly, in time permitting, Chief Justice, we will then deal with the unpleaded New Africa challenge and make submissions on why the High Court was wrong when it found that the respondent suffered no prejudice in the court entertaining the unpleaded challenge, even though it wasn't raised at all by the DA in its papers. And then lastly, we'll make a submission or two on the question of relief. If I can then begin with the first topic, and that's to look at the broader context of the VAT Act, and particularly the interrelationship between Section 7.1 and 7.4. We submit, Chief Justice, that the starting point is what this court has repeatedly held, and that is that Parliament has an inherent power to tax. That power is a broad power, and there are no constraints in the Constitution as to how Parliament designs its tax structure. It is in this context that one must view the VAT Act, and specifically Section 7.1 and 7.4 of the VAT Act, bearing in mind the pleaded reason for the specific design chosen by Parliament, which is to enable a short-term solution to accommodate the fact that the legislative process is lengthy and therefore ill-suited to this particular form of tax. As this court recognized in New Africa, it is not practicable to adjust VAT rates retroactively, and so there is no prospect for retroactive national legislation. Also, the Minister tells us that this undermines good governance and sound fiscal management, because the adjustment of the VAT rate has to be factored into the budgeting process. Thus, at the point of finalizing the budget, you need a measure of certainty in order to properly comply with the rigorous constitutional and legislative prescripts that govern the budgeting process. It is against this backdrop that one must view the legislative scheme, taxing scheme, selected by Parliament for the imposition and alteration of VAT. And that scheme, for present purposes, comprises of Section 7.1 and Section 7.4. The wording of Section 7.1 is very significant. It says, and this is the introductory line to Section 7.1, subject to the exemptions, exceptions, deductions, and adjustments provided for in this Act, there shall be levied and paid for the benefit of the National Revenue Fund a tax to be known as the value-added tax. So it's built into the design selected by Parliament that the tax would be subject to adjustments provided for in the Act. Now then, sections A to E of Section 7.1 sets out what goods and services VAT is to be levied on, and the remainder of Section 7.1 sets out the rate at which VAT is charged. All the parties accept that the provision of the VAT Act which imposes VAT is Section 7.1. The court will see that from paragraph 17 of the DA's heads. But in that paragraph, what the DA does not highlight is that in imposing the VAT tax, Section 7.1 expressly provided for the tax to be subject to exemptions, exceptions, deductions, and adjustments. Now, the adjustment contemplated in Section 7.1 is then reflected in Section 7.4. It provides for a very constrained adjustment, and it says if the minister, emphasis on the minister, makes an announcement in the national annual budget, it has to be done in a very specific way at a very specific time, contemplated in Section 27.1 of the PFMA, that the VAT rate specified in this section is to be altered. That alteration will be effective from a date determined by the minister in that announcement and continues to apply for a limited period of 12 months, subject to Parliament passing legislation giving effect to that announcement. So that's how the two sections work together. Section 7.1 expressly contemplates alteration or adjustment under the Act. Section 7.4 gives effect to that by allowing the minister a limited power to introduce such an adjustment. That then brings me to the defining features of Section 7.4. And in addressing the central question which this court faced, which we submit properly articulated, the central question is whether the scheme created by Parliament in the exercise of its power to tax is constitutionally permissible. And that scheme is Section 7.1 and 7.4 working together. And in answering that question, we say that there are 5 features of Section 7.4 which is worth highlighting. The first is that the power may only be exercised by the Minister of Finance. Now, I don't need to address the court on the significance of that part of Section 7.4. The Minister carries with him expertise and the expert support of National Treasury in exercising that power. National Treasury oversees fiscal policy, public finances, intergovernmental financial relations, expenditure planning, and the national budget. That's the first feature. It's the actor. The second is that the announcement must be made in the national annual budget. Now that carries with it 2 significant features. The first is a temporal one. So it can only happen once a year when the annual budget is tabled before Parliament. But secondly, it drags with it the entire process, the complex process which regulates budgeting, particularly national budgeting in the country. And I'll be addressing the court on that shortly. Thirdly, the section provides that the announcement is a temporary alteration in the VAT Act. In the VAT rate, it's not the imposition of a new VAT rate. It only applies for a maximum of 12 months unless Parliament passes legislation to give effect to it. The emphasis here is on alteration. Now, my learned friend Mr. Maneche has addressed the court on the basis that this alteration would always be an increase in the VAT rate and therefore onerous to poor people of this country. We don't dispute that an increase in the VAT rate will be onerous. But this court has to approach the question on an objective basis, bearing in mind that the adjustment could either be an increase or a decrease in the VAT rate. And if it was to be a decrease, the net effect of that would be to benefit the poor of the country for the 12 months that the minister's announcement is in effect. Fourth, the fourth feature is the specific nature of the tax at issue. VAT has very specific features. It's a consumption-based tax. It's levied on the supply or import of goods or services. Revenue is collected transaction by transaction, and if the tax is not levied at the point of supply, it is lost permanently. Unlike income tax, VAT cannot be backdated or retrospectively recovered through assessments. And if additional revenue is required urgently, the adjustment must occur prospectively and in real time. It cannot be made retrospectively. Now these 5 features of Section 7.4 we submit must be considered with the 3 key purposes that's been identified in the pleadings before you. The first purpose behind Section 7.4 is to foster sound fiscal administration. It allows for short-term adjustments to the VAT rate to be announced in tandem with the national budget, ensuring coherence between revenue planning and expenditure priorities. The second purpose is it enables responsive fiscal management without displacing Parliament's ultimate legislative taxing authority. Without such a mechanism, the minister would be left without an effective tool to manage immediate revenue shortfalls or fiscal pressures. Money bills take many months, and that's the evidence before this court, even up to a year to pass. Meanwhile, government may face revenue shortfalls, be unable to meet spending commitments, or be forced to borrow money under pressure. Section 7.4 avoids that risk. It acts as a necessary bridge in a modern economy. The provision allows government to respond immediately while preserving Parliament's power to confirm, amend, or reject the adjustment in due course. And thirdly, it enables the minister to manage the danger of prematurely announcing potential changes to the VAT rate. And this links to the peculiar nature of VAT. Forewarning of a tax could likely affect or influence consumer behavior and the markets, and may therefore jeopardize projected revenues. So in summary, the provision enables the minister to act within a defined and tightly regulated window under direct parliamentary oversight, which I'll take the court through now, and within the framework of public finance legislation, with the rate adjustment lapsing after 12 months unless Parliament acts or enacts legislation to give it permanent effect. I then turn to the role of Parliament, the question of parliamentary oversight. We say that in summary, Parliament has 3 key roles in the process. The first role was devising the scheme which I've addressed the court on, the Section 7174 scheme. It devised the scheme of imposition and alteration, and these 2 sections working together to achieve the governmental objectives already addressed. Secondly, by inserting the requirement that the Section 7.4 announcement be made in the annual national budget, Parliament exercises tight control over the process. And I'll take the court very quickly to what this entails. The starting point, of course, is Section 215 of the Constitution. That section 215(1) says that the national, provincial, and municipal budgets and budgetary processes must promote transparency, accountability, and the effective financial management of the economy, debt, and the public sector. National legislation must prescribe, and that's Section 215(2), which says exactly what must be addressed in national legislation. But critically is 215(3), which says budgets in each sphere of government must contain estimates of revenue and expenditure, differentiating between capital and current expenditure, proposals for financing any anticipated deficit for the period to which they apply, and an indication of intentions regarding borrowing and other forms of public liability that will increase public debt during the ensuing year. So this is the constitutional framework in terms of which the minister acts when he tables the budget in Parliament. Once a budget is tabled in Parliament, and we know that that happens in terms of Section 27(1) of the PFMA. Perhaps I can take the court to Section 27(1) very briefly. It deals with national annual budgets. 27.1 says the minister must table the annual budget for a financial year in the National Assembly before the start of that financial year, or in exceptional circumstances as soon as possible. It then says in 27.3, an annual budget must be in accordance with the format may be prescribed and must at least contain estimates of all revenue expected to be raised, and you will understand that VAT has a direct link to estimates of revenue raised, estimates of current expenditure, estimates of interest, estimates of capital expenditure, and estimates of revenue excluded in terms of 13.1 or 13.2. And it goes on. It has other particular requirements that a budget has to address. Once tabled, the Money Bills Act comes into play. And Section 7.2 of the Money Bills Act provides, Section 7 deals with the introduction of the National Annual Budget. I'm looking at the Money Bills Act now, the Division of Revenue Bill and the Appropriation Bill. So we know that when a budget gets tabled in Parliament, it gets accompanied by the Appropriations Bill and the Division of Revenue Bill. These two bills, which ultimately, if adopted by Parliament, becomes acts, they give effect to what is contained in the budget. So the budget is meaningless unless it's given effect to, and it's given effect to through the enactment of DORA and the Appropriations Act. So Section 7.1, which deals with the tabling of the budget, Section 7.2 says that the budget has to be accompanied by certain documentation. The key one there for present purposes is 7.2a, the proposed fiscal framework. So it's a legislative requirement that your fiscal framework has to accompany your budget when it gets tabled in Parliament. Now, if one looks at the definition in the Monies Bill of a fiscal framework, it says that the fiscal framework means the framework covering the period of the MTEF that gives effect to the National Executive's policy, macroeconomic policy, and includes, this is going to sound familiar to the court, estimates of all revenue proposals, budgetary and extra budgetary specified separately, estimates of all expenditure, estimates of borrowing, estimates of interest. It's exactly the same issues which have to be dealt with in the budget, but just for a broader period. So your fiscal framework will be for a 3-year period, including the period of the budget and the next 2 years. That's your MTF period. Going back to Section 8 then, which talks about the adoption of the fiscal framework. Section 8.1 says that the National Assembly and the NCOP must refer the fiscal framework to their respective committees of finance. So the Standing Committee of Finance and the Select Committee of Finance received the fiscal framework. They have to hold joint public hearings on the fiscal framework. And they ultimately have to prepare a report for their respective houses. This report can do one of two things. It can adopt the fiscal framework, or it can amend the fiscal framework. So whatever is provided for in the fiscal framework, including we would submit an alteration to the VAT rate, has to be either adopted by the select or standing committees, or it can be amended by them. The Act allows the standing committee to directly recommend or report on an amendment of the fiscal framework. And that the court will see from Section 8.4. The report must include a clear statement accepting or amending the fiscal framework. Section 8.5, when amending the fiscal framework, a money bill, or taking any decision in terms of this Act, Parliaments and its committees must. The Act then sets out a procedure that the committees must follow before they amend the fiscal framework. The Act also in Section 8, subsection 6, allows the minister an opportunity to respond to this decision to amend the fiscal framework. The minister is given 2 days to address the select committee or the standing committee on its decision to amend the fiscal framework and to respond to the basis on which it amended the fiscal framework. So that's, Justice Dambuza, in answer to the question, that's the direct role played by Parliament in the adoption or amending of the fiscal framework. And I've demonstrated to the court the overlap between the annual budget, which is tabled by the minister, and the fiscal framework. Parliament's role becomes more acute because it then gets to either adopt or amend the Division of Revenue Bill, which is before it. And that's its first task, once the fiscal framework is adopted. It has to then consider the Division of Revenue Bill. The legislation provides that the Division of Revenue Bill can never be inconsistent with the adopted fiscal framework. And so immediately you see Parliament's role. Once it adopts the fiscal framework, the Division of Revenue Bill can never be inconsistent with the fiscal framework. Similarly, once Parliament is done with the Division of Revenue Bill, it turns to the Appropriations Bill. And the legislation provides that the Appropriations Bill that is ultimately adopted can never be inconsistent with the Division of Revenue Bill, or by then an act, and the fiscal framework. So these mechanics which actually give effect to the budget are all based on the fiscal framework, which is ultimately the one adopted by Parliament. Now, if I can very quickly deal with the submission made by my learned friend, and which the court will find in the decision of the High Court, that what this will depend on, so we know the minister tables a budget. The budget is now inconsistent with the fiscal framework because Parliament, we assume, has now changed the fiscal framework to remove elements of it that it wasn't happy with. And the High Court found that the minister's decision whether or not to withdraw his budget and table a new budget, which is consistent with the fiscal framework, is a matter of what was described by the High Court as ministerial benevolence. So in other words, there's no legal compulsion on the minister to withdraw his budget and to introduce a new budget, and it's left to his benevolence. We submit that that's not an accurate reading of the framework. I've taken the court to what the Constitution requires a budget to address. Now, if the adopted fiscal framework is going to have a fundamental impact, for example, on the estimated revenues, then the minister cannot have a budget before Parliament which speaks to different estimated revenues from what is actually adopted by Parliament and reflected in the fiscal framework. That would be entirely irrational and unconstitutional. The Constitution has specific requirements for the budget, and we would submit that that would be acting inconsistent with those requirements. And therefore, the minister would be required to do what he did in this case, which is to withdraw his budget, to rework the fiscal framework and the basis on which forms the basis of his budget, and to place a new budget before Parliament, which then removes or is consistent with what Parliament has ultimately adopted in its fiscal framework. That's how the whole scheme works together. So that's the second, we would submit, very potent involvement and power of Parliament in the entire process. It happens through inclusion of those few words in Section 7.4, which is that the announcement can only be made in the national budget tabled before Parliament. The third way in which Parliament exercises control is what this court has already dealt with in the course of the morning. It's in the fact that it can ensure that the adjustment lapses without confirming it after 12 months. Now, against that backdrop, I can turn very briefly to the DA's challenges, Chief Justice. And the first is the imposition challenge, and you've heard my learned friend confirm this morning that their case is an absolutist case. They contend that Section 7.4 confers on the minister the power to impose a tax, and they say that this falls foul of the general principle that taxation is a primary legislative power and therefore unlawful. And we've already made the point in the heads, and my learned friend has accepted, that if one looks at the four cases relied upon by my learned friend, Fetcher, Shuttleworth, Casino Association, and New Africa, and not to forget Moslaba, none of those cases deals with a situation which I've described, the Section 7.1 and 7.4 interaction, an imposition by the legislature and the limited power to alter the rate for a limited period. All of the cases relied on deal with the imposition of a new tax. And despite this, the DA has stuck to its absolutist position. notwithstanding the clear authority of New Africa, and perhaps it's a good time to address what we understand New Africa to say. And building on the blocks that New Africa considered Executive Council, it considered Smith, and it departs from the principle that the separation of powers principle is never cast in stone, and that there's never complete separation of powers, and that there is always a partial separation of powers. And the question that arises in any given scenario is, where is that line drawn in this case? Which is why it calls for a contextual approach.